So the Office of Administrative Law, OAL, is charged with reviewing all proposed regulations by California's 200 plus executive branch administrative agencies and departments. And that review process is set forth in the APA, the California Administrative Procedure Act, and the approval process is enumerated in Government Code sections 11349 to 11349.6. As part of that review process, the Office of Administrative Law, again, OAL, is required to either approve a regulation or disapprove it. And this must occur within 30 working days after that regulation has been submitted to the OAL for review. If the proposed regulation is approved by OAL, then OAL simply transmits the approved regulation to the Secretary of State for filing, which is basically a ministerial duty. If the OAL fails to act within that 30 working day period, then the proposed regulation is deemed to have been approved, and OAL is then required to transmit the regulation again to the Secretary of State for filing. On the other hand, OAL has the authority to disapprove a regulation. And if OAL disapproves a regulation, then OAL returns that regulation to the adopting state agency within that 30 working day review period, along with a notice that has to specify the reasons for the disapproval. And then within 7 calendar days of issuing that written notice, then OAL has to provide the adopting agency with a written decision that details OAL's reasons for disapproving the regulation. No proposed regulation can be disapproved except for the regulation's failure to comply with one of the 6 statutory standards of review that are set forth in the Government Code. Now, those 6 standards are authority, reference, non-duplication, clarity, necessity, and consistency. The disapproval process allows the state agency 120 days to fix the disapproved portion and then to resubmit it for further consideration by OAL. Thereafter, OAL has again 30 working days to review the resubmitted documents. Now, in theory, there could be more than one disapproval and resubmission, but that likelihood is very rare. In most instances, the adopting agency complies with the OAL disapproval memo and resubmits it, and then it's approved by the Office of Administrative Law.